Good morning. Happy Tuesday. So, I apologize for not posting more. I'm a country boy now. I got me a farm, so I've been somewhat busy. And, with the two law firms I work for and my own practice, it's been a little bit hectic, but that's a good thing, right? Idle hands, devil's playground, and all that fun stuff. Anyway, a couple updates for you. Earl's trial is set to go forward tomorrow. So, if Earl's innocent, I wish him the best of luck. And if he's not innocent, then I wish the state the best of luck. So there's that. And then on Earl's lawsuit against Leon Valley and Salvaggio, who would have guessed it? Who would have thunk it? But they have filed a motion to dismiss based on the statute of limitations. The continuing tort theory doesn't apply, and qualified immunity. Crazy. Who would have thunk it? I mean, who could have seen that coming? So I don't know if Earl's going to even respond to their motion to dismiss. It's going to require an actual legal argument as to why the statute of limitations is not run and why the continuing tort theory does apply. Like, actually look up a case that is applicable, like the facts kind of gel together with Earl's facts. And so there's going to be a lot of legal research involved if there is a case to be found, if there is something he could find. And I just don't see Earl doing that. I mean, Earl's not a very scholarly person. So I would expect Earl's lawsuit against Leon Valley to get dismissed with prejudice, because if the statute ran, the statute ran. And you could only sue someone over a cause of action arising out of a nexus of facts one time. You get one bite at that apple. I mean, if it's dismissed with prejudice, if whatever you do is dismissed with prejudice, you can't go back and try to find a different cause of action to sue for the same facts. There might be multiple ways to, like, for example, let's just do something really simple. Like, your state may have a cause of action that is similar to a 42 USC 1983 cause of action. And let's say that you decide to sue in only one forum under one of those two causes of action. So either you sue in the state court under their version of the 1983 lawsuit, or you sue in federal court under their version of the 1983 lawsuit. You only do one, right? Let's just say you only do one. You get to court and the court dismisses it with prejudice. You can't go back to the other court and say, oh, well, I want to sue now under the, if you sued in federal court, you can't go back and say, I want to sue under the state cause of action. And in addition, sometimes there are multiple kinds of causes of action in a given jurisdiction. Like in the state jurisdiction, you might be able to sue for wrongful arrest. You might be able to sue at the same time for assault, for battery, for kidnapping, for unlawful or improper imprisonment. I mean, there might be a whole series of things that you could sue for, and if you only pick a few of those and you go to court and they get dismissed with prejudice, you can't go back and sue for the other things because it all relates to the same nexus of facts. And so Earl's in a bit of a pickle with his lawsuit. Now, I don't know if he ever actually intended to do anything with it other than to get clicks and views. Maybe he did, maybe he didn't. I'm not a psychologist or a psychiatrist. I can't read the man's mind. So I don't know why he did it. And I know a lot of you have opinions on why he did it, but I mean, ultimately, you guys are just guessing too. So, but at this point, his lawsuit's just doomed to failure. Like, I don't see a way for him to recover from this unless he gets an attorney, and that attorney can can dive into it and figure out what to do. So, and one thing that I would like to really comment on, and I hope all of you are mature enough to understand this. The state committing an injustice against somebody you don't like should be just as concerning to you as when they commit an injustice against someone you do like. Because when they commit an injustice, if they do it once, they'll do it again. If you don't stop them, they'll continue to push it forward. And I mean, if we allow cops to get away with arresting protesters and for not committing a crime, literally these people were arrested by Leon Valley for just being witnesses. That's what they were claiming when they were being arrested. You guys are witnesses. We're seizing you and we're seizing your cell phones. Do you want that? I mean, is that the kind of America you think we should have? Regardless of whether or not you think the Leon Valley protesters were right, regardless of whether you like James Freeman or Earl Warden, I mean, regardless of whether you like these people, should the cops be allowed to arrest people for the non-crime of being a witness? Should the cops be allowed to seize people's property for the non-crime of being a witness? Should we allow that as a country? I submit to you that we should not. I mean, if this is a nation of laws, if we are subject to the rule of law, then we should not be arrested for being a witness or potentially being a witness. We should not have our property seized for potentially having something on it that the state may or may not like. And the property should not be held by the state unless they get a consent from you to search it. That's just completely violates your Fourth Amendment rights, or it should. I mean, it really should. And I suspect that unless the attorney for the other Leon Valley plaintiffs, unless that attorney really F's it up, he should at least get some sort of declaratory relief that you can't just arrest witnesses and seize their property willy-nilly. I mean, yes, cops can seize witnesses' property, but they have to do so for very specific reasons. Like they have to have probable cause that, like, oh, I have probable cause that your phone has a recording of the actual criminal act. And then they have to take that to a judge and get a warrant to seize the phone. And they might be able to see, like, if they think you're just going to go destroy it, they might be able to seize it and then go get the warrant. And then if they don't get the warrant, they got to hand it back to you. But I mean, we got to have these rules of law, or else you give the government an inch and they will take a mile, and they'll never give you back that inch. They've never given back an inch. They've never given back an inch. I mean, there was a point in time before Terry frisk was a legal thing. You know, people like to get on delete laws because he wants to get rid of Terry and Terry stops. I don't have a problem with that. I mean, maybe the guy's a jerk, a loser, maybe he's whatever. But being able to stop and frisk somebody just because you've got a gut feeling that they were looking into a store window too long. Oh, this guy saw me and started running, so I get to stop him and frisk him? That's messed up. I mean, Fourth Amendment says, probable cause, warrants, probable cause. Why can't we do that? Why can't we do that? I'm sorry. I'm ranting now. So anyway, Warden's trial should start tomorrow unless some other delay comes up. His lawsuit against Leon Valley doomed to failure. They've already filed a motion to dismiss. I don't see him getting out of it. He needs to get an attorney, and I don't think he's gonna. And don't celebrate when the state does injustice to people you don't like, because it's still injustice. Thanks for watching. Have a great day.